My name is Michelle Cubelis, and my research focused on looking at Guantanamo Bay and whether or not it was a form of preventive detention or a violation of due process. My research focused on answering the question as to whether or not President Bush's decision to hold these alleged terrorists at Guantanamo Bay without federal criminal prosecution was both legal and wise. So what does it matter if they were held at Guantanamo? Our criminal justice system is based on the principle that you are innocent until proven guilty. During the War on Terror, the Bush administration completely flipped this idea in a way, in hopes of preventing another terrorist attack. And so all people held at Guantanamo Bay were automatically assumed to be guilty of terrorism or some kind of terrorist act. The inability of the Bush administration to balance civil liberties, due process, and national security led to the violation of the due process rights of these detainees. And as a result, there are numerous instances where innocent individuals were detained at Guantanamo Bay. My research used a qualitative and exploratory approach. I reviewed both legal documents and unclassified government documents, as well as doing an in-depth case study analysis. And I concluded with doing looking at historical precedent for both military commissions and habeas corpus. So, President Bush claimed that all of the detainees held at Guantanamo Bay were terrorists, they'd done something against the U.S., and they deserved to be there. But documents released by the Department of Defense claim something different. These documents showed that at least half of the detainees had never committed any act against the U.S., and between 18 and 40% had no connection to Al-Qaeda, to the Taliban, or any other terrorist organization. And in fact, most of the detainees held in Guantanamo Bay weren't even arrested by the U.S. government. Instead, they were arrested by Pakistan or the Northern Alliance, and often they were sold to the U.S. for an undisclosed sum. No evidence was required for this transaction. All the government had to do was say this person might be a terrorist, might have some connection, and that was enough for the U.S. to take them in exchange for money. The big problem with Guantanamo Bay is that it's eliminated the writ of habeas corpus. Habeas corpus allows a defendant to challenge the legality of their confinement in a federal court. According to Article 1 of the Constitution, it can only be suspended during times of rebellion or invasion. And one of the only times it's ever been suspended in our history was during the Civil War. President Bush has suspended the writ of habeas corpus for all detainees. And to try them, instead of using federal courts, he created these military commissions. They have been used in the past. They're usually only used during times of war, and they're only used in foreign countries where courts aren't functioning or they're not functioning properly. Their original use is to determine whether or not a prisoner is a soldier or a civilian. If they're a soldier, then they'll be transferred to a military proceeding, and if they're a civilian, they'll be given a civil trial. So President Bush's military commissions are a little different. He created them, and then they were later authorized by Congress on 3 different occasions. And what's important to note is in these procedures, the military acts as all parts. They're the judge, the jury, the prosecution, the defense, and sometimes the executioner. So there's really no balance of power within these procedures. The military commissions are supposed to follow the UCMJ, the Uniform Code of Military Justice, and guidelines set out in American common law. But President Bush didn't really want to do this because within those guidelines you have to follow certain due process rights, and instead the executive branch created all of the guidelines that had to be followed. As a result of this, the due process rights of these detainees were violated, and so people ask, how could he do that? How could he just make up the guidelines? During the War on Terror, the Bush administration decided to label these individuals unlawful enemy combatants. And under this classification, they're not POWs, so they're not protected by the Geneva Conventions. And he already suspended the writ, so they don't have access to federal courts. So this kind of gave the Bush administration free rein to deal with them as they chose. As a result of this, there's been an increase in the violation of due process rights. And it's important to note that even if a defendant is found not guilty in one of these military commissions, they're not necessarily released. The Bush administration has reserved the right to hold these detainees, whether or not they're innocent or guilty, until the end of the conflict. So this is a table of the major differences between military commissions, the court-martials, and the criminal trials. The first two refer to evidence. Within military commissions, the government doesn't have to turn over exculpatory evidence, and this is anything that can prove that the defendant is not guilty or that the claims made by the government are false. In both criminal and military trials, that has to be turned over. It's a right in the Constitution. You have the right to see evidence, whether or not it helps you or doesn't. Also, within these military commissions, hearsay evidence is allowed. So if somebody heard somebody say something, that's allowed in these. Whereas in criminal trials and military court-martials, that's not allowed because you can't really verify whether or not it's true, and it doesn't necessarily have the validity that's required. Within military commissions, coerced confessions or confessions gained through torture are also allowed. For various or obvious reasons, these kinds of confessions aren't allowed in criminal trials or military court-martials. You don't know if it's reliable, and often people will say whatever they think you want to hear in order to stop being tortured. The last two deal with the defendant's rights. In both criminal and military trials, the defendant's allowed to choose their counsel or have some say in it, whereas in these military commissions, the defendant is given a military representative who serves as their counsel. And also, in criminal trials and military court-martials, the defendant can't be removed from proceedings. It's their right to be present for the entire trial when anything is said about them or any kind of instance like that. In these military commissions created by the Bush administration, they can be removed at any time for any reason, and all the government has to say is it's classified. So this removes the ability for the detainee to prove their innocence or to even be part of their own trial. So 4 different times the Supreme Court ruled that the detainees did have rights and that the military commissions were unconstitutional. The first was Rasul versus Bush, and this dealt specifically with jurisdiction over Guantanamo Bay. The Supreme Court ruled that the U.S. did have jurisdiction, and as a result, these detainees were entitled to habeas corpus rights and that they did have access to the federal courts. Then in Hamdi versus Rumsfeld in 2004, the Supreme Court dealt with the issue of specifically citizen enemy combatants. And they ruled that any citizen who was an enemy combatant and held at Guantanamo Bay, whether or not it's in the U.S. or outside of the U.S., has access to federal courts and is still protected by the Constitution, still has those due process rights. In the next case, Hamdan versus Rumsfeld, the Supreme Court ruled that these prisoners were indeed protected under the Geneva Conventions, and this regulates how they can be treated, how they have to be tried, and their access to relief organizations or things of that nature. It also ruled, the Supreme Court also ruled that the military commissions were unconstitutional, that they couldn't be used because they didn't conform to the UCMJ and they violated due process. Then, in a final ruling in Boumediene versus Bush, the Supreme Court again, for the second time, ruled that the military commissions were unconstitutional, and that the suspension of the writ of habeas corpus was unconstitutional itself because we weren't in a period of rebellion or invasion. And they specifically stated that all detainees were entitled to access to the federal courts. Despite these rulings, which each time said that detainees had access to federal courts and they were allowed due process, the Bush administration decided not to do it. They did give them a little bit more access to federal courts, but still not the access that they were guaranteed by the Constitution and the Supreme Court decisions. So I concluded with 3 case studies, and these are important because they show how this violation of due process led to instances where innocent individuals were detained by the U.S. government. The first was Murat Kurnaz. He was a Turkish citizen who was arrested in Pakistan in 2001 at the age of 19. He was originally arrested by the Pakistani police, and then he was sold to the U.S. government for $3,000. The U.S. government believed that he was a member of Al-Qaeda and that he was a friend of a suicide bomber, but there is no evidence of this. And in fact, documents released by the government and by the other Turkish and German government show that they all acknowledged he had no ties to terrorism. There was nothing that existed that could indicate that he was any threat, but still he was held for another 4 years. He wasn't released until August of 2006, and he was detained for a total of 5 years. The next was Mozambique. He was a British citizen also captured in Pakistan by Pakistani police in 2002. He was transferred to U.S. custody and then transported to Guantanamo Bay. Now, in this case, the U.S. believed or alleged that he was a member of Al-Qaeda and also that he had actually undertaken hostile acts against the U.S. and that he was a trainer at one of the Al-Qaeda training camps. Again, with his case, there was no evidence, but he was held at Guantanamo Bay. He experienced over 300 interrogations, and he also alleges that he was tortured by the U.S. interrogators. He was eventually released in January of 2005 after spending 3 years in Guantanamo, and this was only after the British government negotiated with the U.S. government for the release of all British detainees held at Guantanamo Bay. The final case study is Omar Qadir. He's one of the youngest detainees captured in the War on Terror. He was captured in 2002 in Pakistan at the age of 15. When he was captured, he was shot in the chest and also in the eye, so he lost his eye, and then he was transferred to Guantanamo Bay. The U.S. government alleges that he threw a grenade at a U.S. convoy and killed a U.S. soldier, so they decided that he needed to be kept at Guantanamo Bay. He's been held there without access to federal courts and without a trial for 7 years now. He's still at Guantanamo Bay, so we're not really sure what will happen to him. We'll have to see how that plays out in the future. Upon taking presidency, President Obama signed an executive order that said Guantanamo Bay had to be closed by January 2010. And he also created a task force which was supposed to review the case of each detainee and determine whether or not they needed to be kept in confinement or tried in a military court or tried in a federal court or released to their country. Despite this kind of advancement in solving the issue of Guantanamo, President Obama never ruled out the use of preventative detention, and as a result, Guantanamo Bay is still open and they're still being detained. Some have argued that we can try them in the U.S. courts and we can keep them in the U.S. And there's been proposals to use old prisons that are being closed down, like Leavenworth. There's one in Michigan, and have them refurbished and have a courtroom built within the prison, and then you can house the detainees in the prison and try them in the same area. But there's been backlash against that because a lot of people say we don't want terrorists on U.S. soil. You know, they can be in the prison, and our prison system isn't secure enough, so they could still have access to outside groups or outside individuals who could still pose a threat. This study was limited in that a lot of the documents pertaining to detainees weren't necessarily unclassified. They weren't public records. So a lot of what I had to do was look for documents online that the government had released and try to piece together that with news articles and things of that nature. Despite the order by President Obama, the detainees are still being held at Guantanamo Bay with very limited access to federal courts. No trial process has been created, no adequate way to try them has even been attempted to be created, so they're still being held and their due process rights are still being violated. And what's also important is there's no accountability. No one's been held responsible for the fact that innocent individuals like the 3 case studies I've discussed were held for years on end by the U.S. government. So now the question remains, what will happen to Guantanamo in the future? Where will the detainees go? And will some kind of compensation be made to those people who were held in Guantanamo Bay when they were innocent?